Okay, good morning, everybody. My computer clock now tells me that we're dead on 9 a.m. and therefore it is time to welcome you to the next instalment of Guildhall Insolvency Team Autumn webinar series. For those of you who still don't know me, I've been in the insolvency team at Guildhall since completing pupillage with Hugh Sims in 2009, so for more years than I would care to admit to. I will be speaking today with my colleague in the team, John Churchill. I noticed that we've both got fairly fulsome profiles in the invitation which has been circulated for this event, so I won't trouble you with a potted bio, provided that you promise on Scout's honour that you will go and commit them to memory after the session. But instead, let's go straight to the treats that we have in store for you this morning. So this is the playbill for this morning's performance. It is in 3 acts and 5 scenes. First of all, in Act 1, I will be setting the scene by reminding you of the transaction avoidance provisions and the source of the statutory discretion as to remedies. And then I'll be taking you through the main decisions that opened up the question of the relevance of the equity change of position to insolvency claims in the first place. In Act 2, we will come to the present attitude of the courts to change of position. And for that, we're going to be looking principally at the first instance decision of ICC Judge Jones in Bucknall and Wilson, and then further in the decision on appeal by Mr. Justice Trower, which was handed down in July of this year. Spoiler alert, it is not available as a defence, but in exceptional circumstances, facts which establish a change of position defence, were it available, will weigh in the balance when the court is considering what order to make. So with that qualified relevance in mind, in Act 3, John is going to consider the authorities on change of position outside of the insolvency context, see what might be gleaned from them in order to assist us going forwards. And finally, if we've got time, we're going to have a little think about what might fall within the narrow band of exceptional circumstances in which change of position factors will weigh in the balance of the exercise of the court's discretion. And so we will begin at the beginning with the statute itself. There are 3 groupings of transaction avoidance provisions where change of position has been raised as a relevant factor to relief. The first grouping is TUVs and preferences. These are governed, of course, by sections 339 and 340, respectively, in the personal insolvency context, and 238 and 239 in the corporate context. The court has got a statutory discretion in either case to make such order as it thinks fit. That's the red wording there on the slide. The blue wording is the purpose of that discretion, restoring the position to what it would have been had that individual, or indeed company, not entered into the transaction in the case of a TUV or not given that preference. There's no statutory guidance on this as to the exercise of discretion, save that there is a non-exhaustive menu of possible orders in section 342 for individuals and 241 for companies. The second transaction avoidance provision is section 423, dealing, of course, with transactions avoiding creditors. These are essentially TUVs plus. They have the additional mental element of being motivated by a desire to put the asset beyond the reach of creditors. Again, you can see the statutory description is there in red, purpose in blue, and there's also a non-exhaustive menu possible orders. But there's one difference in the wording. The word may is used rather than shall. Just hold that in your minds for now. This can be contrasted with the third group, the void dispositions. These are different from sections above because they're declaratory in effect. So the disposition between presentation of the petition and the bankruptcy or winding up order is declared void. Nothing is said about the effect of that avoidance. There's no statutory discretion. There's no list or menu of possible options for orders, although there is a statutory power for the court to validate void dispositions. So focusing at the moment on the first 2 groupings where the court has a statutory discretion, how is that discretion to be exercised? Well, the Court of Appeal had this to say on the matter in the case of Re Thors, that each case would determine its facts, and the task of the court was to fashion the most appropriate remedy with a view to restoring so far as possible, and just to do so, the position that would have pertained had the debtor not entered into the transaction. In deciding how to exercise the statutory discretion, the court inevitably must have regard to subsequent events and to the facts as they are at the date of the order. It cannot turn the clock back and rewrite history. So it seems that we are looking at quite a broad and fact-specific discretion, the worst kind, some might say, in terms of predictability of the outcome. So broad is the discretion, in fact, that as long ago as 1993 in Paramount, which was a preference case, the Court of Appeal considered that, despite the use of the verb shall in sections 238, 239, 339 and 340, the phrase sits order as it thinks fit is apt to confer on the court an overall discretion wide enough to enable the court, if justice so requires, to make no order at all against the other party to the transaction or the person to whom the preference was given. The existence of the discretion to make no order was reconfirmed by the Court of Appeal in Haynes and Hill, although on the facts of that case, it was found there was in fact no TUV, so no question of exercising the discretion allowed by the section arose. Singler and Brown there, I suppose, is the one perhaps infamous case where the court did exercise the discretion to make no order. It was a case on quite strong facts. You might recall that the gentleman who ultimately became bankrupt, who we'll call B, had moved in with his partner. His partner had acquired the right to buy the property of which she was a tenant at a substantial discount. The intention was that she would buy it, he would live there with a nominal interest. He put up all the funds, she was going to pay the mortgage. But unfortunately, when it came time to take out a mortgage, the mortgagee required the property to be acquired in joint names, which it was. It was in fact acquired as joint tenants. A month later, she realises from an informal conversation that she has with a legal exec that the effect of the purchase as joint tenants is essentially that they own the property jointly. And she tries to remedy that by giving a notice of severance to B. Of course, this would normally have the effect of making joint tenants in common in 50-50 shares, and that's the effect of the case of Goodman and Gallant, which is a very useful case. In this case, she specified the property was henceforth held by those tenants in common, 99% to her, 1% to B. He signs and accepts what is effectively a declaration then. The bankruptcy order is made. The trustee seeks to set aside the transaction as effectively being a transfer. 49% of the property which had belonged to his partner. The court accepts this is a TUV, but given the effect of the severance notice was to give effect to what had been intended all along, mortgage payments were repaid by the partner. The circumstances of the case were exceptional and justice required no order to be made, notwithstanding conditions the application of the section were otherwise satisfied. We get some more useful guidance on when it's appropriate to make no order for Mr. Justice Mann in Ramratton. He emphasises the purpose of section 339, so the TUV section, and its allied sections, which means preferences, is to prevent a bankrupt from defeating the aim of a pari passu distribution of his assets and transactions. And since that is the underlying principle, he says it will require something unusual to put it at its lowest for the court to decide that notwithstanding the fact that it's ostensibly a qualifying transaction, the asset can properly be left outside the scope of the bankruptcy. He describes this as a departure from the norm, or that there has to be something unusual, and bearing in mind the wide scope of the norm, it might be thought to be very unusual to allow the court to exercise the jurisdiction that prima facie ought to be exercising. And so we reach the meat of today's talk, the introduction of the actual concept of change of position into consideration of the proper remedy in transaction avoidance claims. It's more usually raised as a defence in unjust enrichment claims. Change of position sort of does what it says on the tin. In essence, it arises when the recipient of funds has so changed their position that it would be inequitable to require restitution. It's a very brief explanation, but I think it will do for now because John is going to enlighten us more in due course with a lot more detail about this defence. The case that really started the ball rolling on this, I think, was Rose and AIP Group UK plc, which was a Section 127 case. In that case, Mr. Nicholas Boren QC, who was sitting as a Deputy High Court judge, pointed out that Section 127 of the Act does not address the consequences or remedy the invalidity. Thus, it appears the remedy must be restitutionary. He further held that since the change of position concept is an inherent qualification to the right of restitution, it couldn't be ruled out as a possible way of resisting a claim by a liquidator for repayment of a void disposition, despite the general statutory scheme and policy of equal distribution among creditors. And so, against that background, we come to seminal case 4N. The facts themselves can be shortly stated for our purposes. The claimant company had been granted summary judgment on its claim for fraudulent misrepresentation, arising out of a share purchase agreement where the defendants had given warranties which they had known to be false. The claimant, as a creditor, subsequently successfully applied into the Insolvency Act 1986, Section 423, alleging the defendant had transferred family home and monies in a joint bank account to his wife for the relevant purpose of shielding them from the claimant, and seeking orders requiring her to repay monies and restore property so that it could execute against them to meet the awarded damages. So far, so good. but it's what Mr. Justice Sales said along the way that was rather controversial. He pointed out that when considering Section 43, that while it does not specify any particular mental state or action on the part of the transferee as a trigger condition for liability, that didn't mean that such matters were irrelevant for defining the extent of the liability or the order to be made at the next stage of the analysis when the court is considering the question of remedy. In fact, in his judgment, the nature of any order and the extent of the relief granted should take account of the mental state of the transferee of property under a relevant transaction, and the degree of their involvement in the fraudulent scheme of the debtor or transferor to put assets out to creditors. This was because, in his view, the application of the statutory regime should reflect general principles inherent in other areas of the law, which treat the mental state and degree of involvement of a defendant in wrongdoing as relevant to the extent of recovery available against him. He said, although the trigger conditions for liability to make restoration under Section 423 set out the basic balance to be struck between the interests of the creditors and of a transferee as established by Parliament, the making of an order under Section 43 and Section 425 necessarily requires some further balancing of the interests of the transferor's creditors and of the transferee to be determined by the court. Since, and this is the important bit, by the time the court has to take action, events will have moved on from the transfer, and the balance of equities between creditors and transferee may well have been affected by changes of circumstances over time. He gave a number of examples. The first was where a transferee may have received a gift of money in good faith without knowing that the transferor acted with a relevant purpose in making the gift. In such a case, a broad analogy may be drawn with claims based on unjust enrichment, such as a claim for money paid on the basis of a mistake of fact, where the recipient's interest in being able to rely on the security of his receipt is overridden by the unfairness to the transferor of being held bound by a payment made by him by reason of a mistake. In relation to those sorts of claims, a defence of good faith change of position on the part of the recipient applies. He referred to Lip and Gorman. So in his view, if the transferee in the example had changed his position on the basis of a receipt in a way that would make it unfair to require him to repay the money, and the example that he gave was thinking it was a completely valid gift, the recipient has spent the money on a world cruise he wouldn't otherwise have taken, in those circumstances, it wouldn't be appropriate for the court to make an order under Section 425 for the transferee to pay back a sum equivalent to the amount that he had received. He contrasted this with another situation, which is where the asset transferred had remained with the transferee, who had simply held it while its value fluctuated in line with market conditions. The appropriate order in that case would be for an order to transfer the asset either to the creditors or to the transferee. At the other end of the spectrum, if the transferee had taken property knowing it was transferred for a relevant purpose and had sought, in fact, to further that fraudulent design by lying to the transferor's creditors to further shield property, it would be inappropriate not only to make an order for throwing the property back, but also to make a money order to provide a sort of equitable compensation to make up for any loss in value of the property. The representative for the wife in 4N also submitted that before making any order, the court should also seek to take account of her own needs, her financial requirements, and her quality of life as an additional defence. Against this, it was argued that the relevant legal principles to be applied shouldn't depend on a potentially wide-ranging and unstructured inquiry, which will go well beyond what the court is required to focus upon in making property adjustments, and would probably add significantly to cost and length. And Mr. Justice Sales agreed with this. And he said there was a comparatively narrow scope for limited recognised principles, such as a change of position to take into account, that there was no wider balancing exercise to be undertaken. So we then come to Claridge, case which was decided subsequently, and again a decision of Mr. Justice Sales. This was an appeal of a decision concerning a DUV, as opposed to Section 43 case. In this case, the husband and wife had owned their home jointly. The husband had been made bankrupt, and the wife had purchased the trustee's interest when she became the sole beneficial owner. Sometime later, the wife and husband had taken out a joint mortgage, and the full amount advanced was used to pay for improvements to the property which belonged to the wife. The husband then became bankrupt again. In reality, it was the wife who met the mortgage payments. There was a transfer at an undervalue of the husband's share of the mortgage proceeds to benefit the wife because it was used to improve her property. However, she acted in good faith when changing her position by using the money for improvements, and she also remained liable to repay the full mortgage sum under her covenant to repay. When considering what order ought to be made to restore the position to what it would have been had the transaction not been entered into, Mr. Justice Bales decided this was an exceptional case, so it justified making no order. He referred to 4N and his decision, and the fact that the transferee had changed her position in good faith. And he decided it is appropriate to take account of any change of position on the part of a recipient of a benefit under the transaction where it is made in good faith. Now, 4N has also been cited in other subsequent cases without any criticism and with apparent approval, and I have referred to 2 on the previous slide, but it's also been roundly criticised for being pairing curiam, and these 2 pieces on current slide make quite interesting reads. I hesitate to attempt to summarise or paraphrase the work of Professor Good. It was very erudite, but the 3 main criticisms that he appeared to advance were, first of all, that the transaction avoidance provisions are concerned not with the resolution of claims between private parties, but with the protection of creditors in winding up. They have the specific policy of protecting the value of the company or the individual's assets. By contrast, the principles of unjust enrichment are targeted wholly to dealing with striking a fair balance between 2 parties, the party that mistakenly pays away the money and the party that's innocently received it. The application of those principles in an insolvency context should have the effect of giving the transferee an unfair advantage over the body of creditors, which is inimical to the underlying, obviously, policy of pari passu distribution. Change of position, therefore, shouldn't be identified as a defence because it does nothing to mitigate the loss that's suffered by the creditors. Secondly, where legislation contains detailed remedial provisions, it's not open to the court to invoke common law rules to confine the discretion given by the court, by the statutory provisions, or to bypass restrictions on remedial relief imposed by those provisions. And thirdly, the court's discretion in fashioning the remedy is to ensure the remedy is tailored to the purpose of restoring the position to what it would have been if the company had not entered into that transaction, rather than to allow the court to take advantage and account of hardship for the transferee. Further, there was a case decided by the Privy Council called Conway, where the Privy Council addressed the availability of change of position defence within the context of the Cayman Islands company law. Obviously, this is a decision that isn't binding in UK courts, but it is persuasive given the experience of judges. The board considered there was a well-established principle of public policy which denies effectiveness to avoidable preference without picking and choosing according to the detriment which may be suffered by the preferee as a consequence of its operation. The consequence of that conclusion is there's no room for a change of position defence under Section 145 of the Cayman Companies Law, because the purpose of the statutory scheme would be frustrated otherwise, and it can't be argued that compliance with the statutory scheme is unjust. Although the board concluded it wasn't the occasion on which to decide whether or not the reasoning in 4N was correct, the discussion of paragraphs 113 to 117 of the judgment is really sympathetic to a conclusion that the availability of the change of position defence in a statutory callback claim would in fact be wrong in principle. So this brings us on to the present position and the most recent case considering the relevant change of position, Bucknall and Wilson. The background in this case was a dispute between father and son about the running of their property development business, which ultimately led to an adverse judgment against the father and his bankruptcy. ICC Judge Jones accepted that during the currency of their dispute, bankrupt retained his stepdaughter, a forensic accountant, to draw up an account of property dealing at £40 an hour to be paid when the bankrupt could afford to settle her invoices, which collectively amounted to some £99,330, so an awful lot of hours. Perhaps with hindsight, maybe regrettably for the trustee, it appears that it was never suggested at the trial that the sums that were invoiced didn't represent a fair and reasonable value for the work that had been carried out, and the judge accepted that it did and characterised the sums therefore as an arm's length and commercial debt. Adverse judgment having been delivered on the 15th of July 2014 for a sum in excess of £100,000 plus interest and costs and a Part 36 payment, the bankrupt then went on to sell some property in August 2014, and he used the net proceeds of sale of that property to pay various debts, mostly related to the cost of the litigation, as well as a little less than half, so about 48% of the debt that was owed to Ms. Wilson, and that was paid in September 2014. Nothing at all was paid in respect of the judgment debt, Mr. Fowles then became bankrupt on the 22nd of March 2016, presentation of the petition having taken place on the 19th of January. Beg your pardon, 22nd of March 2017, presentation having taken place on the 19th of January 2016. So it can be seen that Ms. Wilson, because she was a relative as a stepdaughter and therefore an associated bankrupt, was caught by Section 340 because her payment was made within 2 years of the bankruptcy. The other debts paid by the bankrupt were not caught because of the 6-month equivalent period applied to them. So it was only Ms. Wilson in the event that was pursued, and the trustee brought a Section 340 claim against her for a preference. Ms. Wilson defended the claim partly by challenging whether the bankrupt was actually insolvent at the time, partly by disputing the desire to prefer, and finally, and relevantly for today, by asking the court to exercise its discretion to make no order. The judge found the bankrupt was insolvent at the relevant time, and the presumption of a desire to prefer had not been rebutted. As to the discretion point, though, Ms. Wilson had given evidence in her witness statement that she was unable to pay back the funds, to give evidence to the state of her finances. Her income depended on a soft furnishings business she ran from home, as well as modest maintenance payments from her ex-husband under the terms of her divorce. She wasn't able to remortgage her home given her modest income, and ultimately, therefore, she could pay no more than a nominal sum back without having to actually sell her home and move to a cheaper area. It was found that her interest in her home was worth about £225,000, and she claimed that after repayment of the sums that were claimed, she wouldn't be able to afford a premises big enough either to continue her business from home or to be able to rent premises for her business, so her business would come to an end effectively. And also that her children, who were aged 14 and 16 at the time, would have to change schools at an important educational stage. However, Ms. Wilson did not actually describe what had happened to the payment that she'd received from the bankrupt in her witness statement. Instead, she explained this in answers to questions put by the judge during her cross-examination. The explanation that Ms. Wilson gave was that she'd had to borrow money from her father to prop her up financially, especially when her marriage broke down and following her divorce, which would have been during 2013 and 14. No time for repayment had been specified by her father, and it was jokingly described as an advance on her inheritance. So her father was not expecting it to be paid, essentially. But her father's financial position then deteriorated as a result of losses on the foreign exchange market, and as his daughter, she felt morally obliged to repay him when he was most in need, and therefore most of the payment was used for that purpose, and the balance of it was used to help her pay for her living expenses, including repaying some credit card balances. Final piece of the puzzle is that the sums received from the payment by the father were no longer available to him by the time the claim was notified to Ms. Wilson by the trustees, although the evidence on this is a bit sketchy. He had, in fact, had to spend it largely to pay for his wife's cancer treatment during 2017. He had no assets to assist her, and he was living on a meagre pension. So it really is a tale of woe. So in the circumstances, the judge found that Ms. Wilson had changed her position before the nature of the claim was indicated to her by the trustees. She did it believing that she had received valid payment for the work that she had done and for which she had invoiced. The judge therefore considered that Ms. Wilson's answers raised a possible change of position argument to the extent that one's available in answer to a preference claim. But because change of position wasn't addressed by the parties in the trial, it came out in the course of the evidence, the judge decided the best course of action was to circulate a draft judgment and invite the trustee to provide written submissions concerning the law and its application to the trial. A bit of an unusual approach, to say the least. Ultimately, he concluded that change of position could not itself be a defence, as the remedy to TV and preference claims is statutory, and there's no references in section 340 or 342 to change of position. The issue, therefore, was whether change of position or similar was a factor which could be taken into consideration in exercise of the court's discretion. He held that it could, and he based that on the case law that we've just looked at, particularly for N. He recognised it wasn't binding as precedent because it concerned section 440, not section 340, but it was a similar statutory provision, is how he described it, and also it was a decision of a High Court judge which had followed insofar as content and purpose was consistent with this section 340 claim. As to that, the trustees submitted that section 340 could be distinguished from section 423, because section 423 can be brought by individual creditors as victims of an impugned transaction, whereas Section 340 claims can only be brought by trustee in bankruptcy. So that means that inevitably under Section 423, a balance would have to be struck between the interests of individual creditors, where they bring the claim, and the third-party transferee. They also drew attention textually to the use of the word shall, which we've seen is used in Section 340, as opposed to may, which is used in Section 423. And they submitted that supports the idea that the statutory discretion is wider when may is used, which makes logical sense within the context of the court potentially considering competing individual interests, which might arise in Section 423, rather than trying to balance interests of transferee with all of the creditors and the interest of the trustee themselves in having the costs paid. So the judge wasn't really persuaded by that reasoning, and the reason why he wasn't is because warrant had already been applied by Mr. Justice Sales himself to a case in the context of Section 339, which was Claridge, and 339 and 340 were very similar. And so the same broad analogy with unjust enrichment had to be made in Section 340 as had been made in Claridge in Section 339. And in any event, he found had he not been bound by precedent, it was still difficult to understand why that would be the correct approach, because it follows logically from the binding court of civil authority in Paramount, which established the court had an unfettered discretion not to grant relief. There being no exclusion to that unfettered discretion, the facts and matters relevant to the transferee. So it came time to actually exercise the discretion. To ICC Judge Jones, there were 4 relevant factors. The first was the fact that it was a commercial relationship and an arm's length payment, which hadn't been actually influenced by the fact of association between the bankrupt and Mrs. Wilson. Because in fact, Mrs. Wilson was preferred less than the other creditors and not more by reason of her association. So the facts do not fall within the normal case or the usual justification for distinguishing family and associates by giving a longer 2-year clawback period instead of 6 months. Secondly, Ms. Wilson acted in good faith. She had no reason to question the payment. I have to say I read this part of the judgment with something of an eye roll, only because she's a forensic accountant. She spent 2,000 hours going through her stepfather's business transactions. Is it realistic that she would have had no idea of his solvency or his intention to pay her and not pay the judgment debtor? I suppose, could more progress have been made in cross-examination here? It's a salutary lesson, I think, maybe for future preference claimants to focus more attention on investigating the very state of mind, since it seems that now is going to be relevant. The payment, the third factor was the payment or realisable asset purchased with it was no longer available to her. This was described by the judge as the prerequisite for exercising the discretion to grant no relief. So in other words, it was a necessary condition in his mind, although, as we'll see, not a sufficient one. While the trustees were understandably irked that a change of position had only really become an issue as a result of judicial interventions at the trial, the judge considered Miss Wilson's financial position generally had been in her witness evidence. It had never been suggested that she retained the payment. The new change of position evidence was not needed to establish, therefore, the prerequisite only fleshed out what happened to the money. However, the new evidence was relevant when considering the guidance of Mr. Justice Sales in 4N that it wouldn't be appropriate for the court to make an order for restoration in respect of a recipient who has changed position on the basis of the receipt in good faith, i.e. without knowledge of the possibility of a preference, in a way that would make it unfair to require a payment of money. The judge considered that the facts of Bucknall in fact provided far more support for a view of unfairness than Mr. Justice Sales' own example of the person who received a payment thinking it was a valid gift and then spent the money on a cruise. He said, there is no suggestion from the evidence that Ms. Wilson dissipated this sum with knowledge that it was or even might have been a preference. While some of the money paid off existing debt, and therefore an order for recovery might be viewed as superseding financial obligation, the majority repaid her father in circumstances where he was not expecting repayment of the sums provided to prop her up financially. Nor can that repayment be criticised when his financial position had altered radically and the money was required to pay for his wife's medical bills. The fourth factor was Ms. Wilson's existing financial position and inability to provide restoration without the sale of her family home. Even if the court should only be concerned in this context with restitution of the payment, and not with interest or costs, repaying the preference would leave Ms. Wilson with net proceeds of sale of £175,000, which would be insufficient to purchase her a new home, although it might pay rental on a home for some years to come. However, the judge said there was no doubt, based upon the facts, that Ms Wilson and her children would suffer mentally, both individually and as a unit, from the sale of the home through no fault of their own. And that will mean restoration of the payment will have a significant and wholly disproportionate effect on her when compared with the receipt into the bankruptcy estate of a sum less than £50,000. So with Factor 4, ICC Judge Jones does appear to have been engaged in a cost-benefit exercise, or a sort of proportionality review, weighing up hardship individually to Ms Wilson as transferee against the benefit to the estate as a whole, and seeing whether one is worth the other. 2 points were made by the trustee on this. The first is that such consequences are not uncommon results of litigation. They would arise precisely because Parliament's intention was to ensure that one creditor does not obtain a preference over others. And the second point was, in any event, this factor is irrelevant as a matter of law because of what Mr Justice Sales said in 4N. The court shouldn't consider matters such as the transferee's own needs, financial requirements and quality of life as part of a wider balancing exercise. One might have thought these were fairly convincing points, but, well, at least to my way of thinking, but ICC Judge Jones didn't think so. He thought it was right to say that these consequences were not uncommon results of litigation, but that Parliament had created a discretionary remedy recognising that the unfairness and injustice should and could be presented when it was just to do so. And as to the second point, the judge reminded himself that 4N wasn't binding on him, although the guidance should be treated with respect, and considered that Mr Justice Sales was not laying down a blanket exclusion. The court shouldn't carry out a balancing exercise in respect of all of the interests of those who could benefit or lose from the decision, conducting a wide-ranging and unstructured inquiry in order to decide the appropriate relief. But the fourth factor wasn't, in his mind, part of a wide-ranging balancing exercise, but simply a factor relevant to Ms Wilson that goes to the issues of justice and fairness. He ultimately decided that he should and may take the family consequences into consideration. But importantly, he recognised that Ms Wilson must establish the overall facts to take the case out of the wide scope of the norm. Assessing Ms Wilson's family circumstances on their own, he concluded they didn't establish the most exceptional case. For example, he said no one is seriously ill, no one has special needs which require the current location. That wasn't to undermine the adverse effects and the consequences of sale on Ms Wilson and her children, but to recognise the strength of the scope of the norm resulting from the statutory scheme and the policy of equal distribution. Nevertheless, he considered those circumstances were a relevant factor to be taken into account, together with all of the other factors, when deciding if this was an out-of-the-norm case. And so, to the conclusion, ICC Judge Jones found that the first and second factors formed what he called an important foundation for Ms Wilson's argument that the case was out of the norm. He said he wouldn't be considering exercising his discretion if the payment had been a gift or a TUV, or she had had actual or constructive notice that the payment was a preference. To be added to those foundations was the establishing of the prerequisite. He said the first two factors would be insufficient without the prerequisite, i.e. that the payment was no longer available to her. Nevertheless, he said that those three factors wouldn't be enough. Either the change of position or the disproportionate consequences had to be added on to move the facts of the case out of the norm. The guidance of Mr Justice Sales in 4N, he said, makes the change of position a strong factor. When added to the first two factors and proof of the prerequisite, it took the case beyond the wide scope of the norm. Therefore, justice and fairness required no order to be made. He also concluded that he would have reached the same conclusion without considering change of position. This was because the fourth factor had such disproportionate consequences that when added to the first two factors, it wouldn't be just and fair to order repayment, knowing the only source was her home. Further, he said, had he not been able to take into account either the third or fourth factors in the exercise of his discretion, he would have addressed them all together as part of consideration of the ex parte James principle, and he found that the right-thinking person representing the current view of society would not consider it right to exercise legal rights resulting from a preference in this case. Not when the result would be to achieve the sale of a family home of a mother without any other significant assets when she received the payment as a commercial debt payment without knowledge and the prerequisite is met. So, the trustees had, unsurprisingly, made a request for adjournment and directions to enable them to test the evidence that came out that was relevant to change of position, because this had obviously come out at trial. This request for an adjournment was refused, seemingly essentially because Miss Wilson's evidence had always been that she no longer had payment, and the trustees could, and by extension in ICC Judge Jones's mind seemingly should, have conducted investigations earlier as to what happened to the payment. This is quite a controversial position, given the fact that the usual rule in restitution is that the elements of the defence of change of position have to actually be specifically pleaded. His second reason was, well, it doesn't matter because the same result will apply even if the third factor is excluded from consideration when exercising the discretion. And finally, in any event, the principle in ex parte James applies, which isn't dependent on the change of position. It will come to no surprise to anybody here that the trustees appealed this decision. There are a number of grounds of appeal, and some made similar points, but in different ways. In summary, they related to four main points on the slide there. Of these, it's number 2 that's the big question, the relevance of change of position. So it makes sense to take this first. Mr. Justice Trower went through all of the case law in meticulous detail. Do read it if you have an interest in this area. It's a really good judgment, I think. He considered that care had to be taken in transposing the principles established by the cases on section 423 into the context of a statutory clawback claim under section 339. He thought there were 3 reasons why it might be more appropriate to carry out the balancing exercise between the interests of creditors or victims of the transfer on the one hand and the transferee on the other in a section 423 case that wouldn't apply in a section 339 or 340 case. First, the jurisdiction in section 423 exists independently of the statute that provides informal insolvency. So the statute therefore contemplates the single limited victim case. So it's more likely to be possible and practicable to balance the justices, the competing justices between a victim of the transferor and an innocent transferee. That wouldn't always be possible, usually wouldn't be possible, where the balance had to be drawn between the innocent transferee and all of the creditors and the office holder's interest in the cost of the policy. Secondly, there's no statutory clawback period in a section 423 claim, whereas the relevant time provisions of section 341 reflect the legislature's intent that is only during a limited specified time period that pari passu distribution has what amounts to retrospect. It follows that the opportunity for the passage of time to affect the balance of equities between creditors and transferee is likely to be materially less significant, whereas section 339 or 340 claim is made because you're looking at a maximum period of 5 years for a TEV, 2 years for a preference, and 6 months in the usual case for a preference, whereas in section 423 there isn't a clawback period. The language of section 423, remember that may as opposed to shall, is also less imperative than the language of section 339 and 340. So that's not to say that the language of section 339 and 340 excludes the discretion to make the order. The court still has discretion, but it is expressed in a manner less consistent with carrying out the balancing exercise, which was contemplated by Mr. Justice Sales. And in Mr. Justice Trower's view, the likely explanation for that difference in wording is that the intervention of the statutory distribution scheme on a formal insolvency is less consistent with carrying out that exercise than will sometimes be the case when there is a claim under section 43. Further, in Claridge, while Mr. Justice Sales had adopted his reasoning from 4N, the ratio of his decision was that in the very peculiar circumstances of that case, there was no simple way to restore the position to what it would have been had the transferor not entered into the relevant transaction. So the case could equally be described not as an application of change of position, but a straightforward application of the words of the statute and usual facts, the statute requiring the court to concentrate on the relief that restores the position when crafting the form of the order. In fact, the transferee in Claridge could never be restored to her original position because she would always have the mortgage debt. So, it followed from his analysis of the case law that the right approach was that change of position does not operate as a defence under section 339 and 340, but there would be exceptional circumstances in which the fact that established a change of position had been available will weigh in the balance when the court is determining how to exercise it as to the order it thinks fit for restoring the position, what would have been if the transaction had not been entered into or the preference had been given. In any event, change of position is not the wrong thing considered it to be. To characterise it in that way was to give insufficient weight to underlying policy considerations illustrated in one way, and the difficulty of balancing the interests of a class against the interests of an innocent transferee. So whatever the case might be under a section 423 claim, where the court was concerned with the appropriate relief to be granted in preference or transactions and undervalue claim, it's rarely going to be possible to give weight to the change of position by the preferee or the transferee, while at the same time honouring the policy reflected in the statute of pari passu distribution. There will be the very occasional case, and Claridge is probably one, where that proves to be possible, but in my view, such cases will be rare. For the reasons I've sought to explain, the position in a TUV or preference claim is not so clear-cut. Beg your pardon. The position is not so clear-cut in relation to a section 423 claim, where the transferor is not subject to formal insolvency proceeding. So there's a distinction to be drawn between section 423 and section 339 and 340. Having found it wasn't necessary for him to decide on this application whether he thought that forang was wrongly decided, because the context of section 423 is different from 340, he did, however, go on to give some guidance to section 423 cases. He said, although the World Cruise example given by Mr. Justice Sales must be read as a finding that change of position operates as a complete defence, that is not how his judgment has been read in subsequent authorities. It operates as no more than one of the factors that might affect the balance of equities between creditors and transferee in circumstances where it is possible to carry out that balancing exercise, when the court is determining the relief, if any, to be granted. The policy that underpins the statute means that the balance is only likely to come down in favour of the transferee where the circumstances are sufficiently out of the norm to be exceptional. Going back to round one, on the procedural point, the judge, whereas ICC Jones seems to have taken the view that once it was accepted, the payment was no longer in Ms. Wilson's possession, the next obvious question for investigation was what happened to it, and the trustees should have done that. Mr. Justice Power helpfully confirmed, for the benefit of trustees everywhere, that the difficulty with that approach was that it essentially reversed the burden of proof, which was on Ms. Wilson to establish the facts that she alleged, by instead requiring the trustees to have investigated what happened to the payment. And while this might have been a prudent thing for the trustees to do, they weren't under any obligation to do it until the point was raised against them. The judge had lost sight of the limited role which his own questions should have had. Instead of exploring defences that had been raised, he was helping to improve the defences. And Mr. Justice Trower accepted that having elicited the evidence, the cat was out of the bag, but the right way to proceed at that stage would have been to give the trustees a further opportunity to put in evidence and cross-examine Ms. Wilson. In any event, the judge was unconvinced that the evidence actually did amount to a change of position, because there wasn't really any evidence to establish how much of the payment had been paid to the father. Evidence as to when that had happened wasn't very good. It might have been after the trustees left the claim. And there was also evidence that some of the payments had been used to pay normal debts and expenses, which wouldn't have constituted because they were pre-existing debts that had to be paid anyway, and might well have augmented the value of Ms. Wilson's property if, for instance, it had been used to pay the mortgage. But having found that the judge gave too much weight to change of position as a factor, and that change of position did not really apply on the facts, the trustee might have been forgiven in reading this judgment with the optimism of somebody who believes themselves about to be confirmed to be on the winning side. Surprise! As we'll say. Despite accepting that ICC Judge Jones's conclusion, while one with any court have sympathy was at first blush a puzzling one, he went on to agree with it. And he did so for 4 reasons, which broadly follow ICC Judge Jones's 4 factors, with at least one important addition to the reasoning, which is factor 4. He said, yes, the unfairness the judge was getting at in his factor 1 was the disparity between Ms. Wilson and the other creditors. Despite them all being arm's length commercial transactions, Ms. Wilson could be pursued due to a more generous limitation period that applied to associates, even though in this case, her association was only relevant to the bankrupt in the sense that it disadvantaged her because it actually led to her being paid less than the others who were paid in full. And that situation is far from the norm, and one of those very rare cases in which the fact that the elements of a preference were established does not mean the strong policy imperative to restore the payment for the benefit of the creditor as a whole is actually engaged. He also found the judge's second factor, so good faith on the part of Ms Wilson, was a necessary but not sufficient condition. The judge's third factor was irrelevant in respect of change of position, because of course that hadn't been made out on the facts. What Mr Justice Trower didn't go on to do is explain what he would have found had it been made out on the facts. Would this have been a relevant factor? He did say it wouldn't have been a strong factor, but would it have been persuasive? We don't know. But he did go on to say that the fact that Ms Wilson no longer has the payment was important to underpinning the argument that no relief should be granted, because if she still had access to the payment, she'd have a less powerful case for arguing the impact of her on having to restore the payment would be disproportionate to the benefit to the estate. The fourth factor that was relevant to Mr Justice Trower was expressed rather differently. He said not just that there would be a disproportionate impact on Ms Wilson, but that this was, all intents and purposes, a single creditor bankruptcy. The only creditor who was left was bankrupt's son, whose judgment debt was unpaid. In the wholly exceptional circumstances in which there is only one member of the class, there is less reason to favour the class over the recipient, and it is more practical, so long as the circumstances are otherwise exceptional, to make an assessment of the comparative position of creditors and preferee than is normally the case. In short, the present case is one of the very unusual ones in which it is appropriate to carry out the broader balancing exercise to which the judge had regard in his Factor 4. So that was the Court of Appeal's decision on Bucknall. I'm going to hand you over now to John to continue.
Thank you, Holly, and good morning, everyone. As Holly has said, I am dealing with Act 3, which is looking, before we turn to consider where the position is after Bucknall, at where we stand on the change of position defence in other non-insolvency claims in restitution. If I start where Holly left off, which were the conclusions by Mr Justice Trower on when change of position would be available, it was clear from Mr Justice Trower that it would not operate change of position as a defence in and of itself in section 339, 340 and 342 claims, i.e. The preferences that were an issue in that case. That was a very tightly drawn conclusion, and he was very clear on the circumstances to which he was going to be limited. But he went on to say that the facts of a change of position may operate to weigh in the balance when exercising the discretion. And so whilst change of position doesn't operate as a defence in law, the facts which may make out a change of position claim will in some circumstances be relevant. So it's not change of position, but it has to look like it. And so for those purposes, we're going to quickly take you through where the change of position defence stands in restitution. If I start off with Lipkin Gorman and with the sage of restitution, who is Lord Gough, was Lord Gough, that is the case which everyone learns about at law school and remembers vaguely, but is to do with the solicitor who had a fraudulent employee who spent a lot of the money he had stolen at a casino, sometimes successfully, but more frequently not. And the issue in that case was whether the casino, having received the payments with sufficient knowledge, were able to offset some of the winnings that had been made by the fraudulent employee when making any restitution back to the solicitor's firm. And the basic definition of change of position was outlined by Lord Gough in the passage that appears on your slide there. There are 3 points that I sort of really want to draw out from this. Firstly, Lord Gough was abundantly clear that this is going to be a very broad defence. And so he said he didn't want to state it any less broadly than that the defence is available to a person whose position has so changed that it would be inequitable in all the circumstances to require him to make restitution. If you go back to what Mr Justice Trower said in Bucknall and said you need to establish the facts of a change of position, given the breadth of the test that is set out there in Lipkin Gorman, you might sensibly say that actually you're not much clearer on what facts need to be established, given that the initial test is so broad. Secondly, the point that's made in change of position generally is what Lord Gough says, that the defence operates to not require someone to make restitution, or alternatively to make restitution in full. So the change of position defence shouldn't be looked at as being a binary option of you either make restitution or you don't. And some of the cases on change of position are quite useful in seeing how the courts operate in fashioning a remedy which gives some opportunity for the recipient to reverse the change of position if they can, or mitigate some of the effects that the change of position has had on them. And then the third factor to pull out from this definition is that Lord Groff is abundantly clear that this isn't just a defence that operates when there has been a payment of money, and that's the bottom part of the definition there. There's a mistaken assumption which he tries to dispel, that the mere expenditure of money may be regarded as amounting to a change of position. So if it is merely raised against a trustee that a change of position has happened but his money has been spent, the argument has to be put strongly back that the recipient probably needs to do far more than that. But as I say, part of the difficulty on the first factor is quite how broadly the defence is drafted. As I say on the slide there is an element of looking through some of the cases and trying to find what is the rationale and the factor that unites them all. The first point on the slide makes abundantly clear, it's Lord Groff in Lipkin again, to saying that this is not just a general matter of discretion to a judge. It has to be operated on a clearer basis than that. And Lord Justice Robert Walker, the Scottish Equitable and Derby case, is abundantly clear as well that it can't simply be a matter of sympathy. There has to be a rational factor to connect all the cases. Drawing the various threads together, Groff and Jones say that if you want to look for the litmus test principle that says when change of position will operate, a good place to start is by asking, has there been an irretrievable loss? Which means not only that if the transaction could be unwound, it's unlikely to mean that a change of position can operate, i.e. if the recipient can unwind whatever they've done with the money, they're likely to be in some difficulty in arguing change of position applies, but also that if the loss isn't irretrievable because it's been moved into an asset, then they're also going to be in difficulty in saying that change of position is available to them. And so the underlying starting point has to be, is the loss that's been suffered by the recipient based on their change of position irretrievable? Based on that, the court then gets into the questions of weighing up whether or not it's equitable in the circumstances to require restitution. So if I move on to some of the factors that are taken in mind in some of the cases, and start with whether or not the benefit that has been transferred and the recipient has had has still in some sense been retained. Lord Templeman used the example in Lipkin Gorman that's first on the slide there, which is if you have bought a car with the proceeds of whatever you have received, you can't say that you've suffered a detriment because the asset is still in your hands. The only potential loss that has been suffered is the depreciation in the vehicle since the time of purchase and whenever you're asked to make restitution of it. A lot of the cases then concern either tangible or intangible property, which is still held by the recipient, but has either gone up or down in value. Perhaps unsurprisingly, because it's not an irretrievable loss. If you've bought shares or you've bought a house and it's then gone up in value substantially, you're in some difficulty in turning around to the person who is seeking restitution against you and saying, I no longer have the asset and I've no longer got the money to pay back to you, albeit there's likely to be an opportunity given either to sell the property or to get a constructive trust on it. And that's particularly been apparent in the real property cases that are on the third point in the slide. If a property has been bought with the money, but the court thinks it's generally inequitable to sell it, one of the remedies that they've chosen in some of the cases is to impose a constructive trust on the property until such time as the recipient decides to sell the asset that they gained with the money they unlawfully had in the first place. If the property is decreased in value, the court's likely to take a slightly different view. For example, if you've invested the money into a property and doing renovations on it, that's generally been treated in quite a few of the cases as having lost the money and therefore rendered it an irretrievable loss. If, however, you've invested the money and it's gone up in value, as I've already said, that's likely to be taken into account by the court. It's not a basis for saying change of position has happened. And so again, if you want to look through a rationale on all the real property cases, which often seem to depart on fairly similar facts, the best place to start is the loss irretrievable. Moving on to financial expenditure and whether or not that can amount to a change of position. As I said in Lipkin Gorman and as Mr. Justice Strauss said in Bucknall, Merely paying off a debt that you were already required to pay is not a change of position. It only becomes a change of position if you've done something extraordinary, i.e. paying off a loan that you weren't required to pay for many, many years, or by paying off an advantageous loan because you didn't think you were going to have to repay the money that you'd received from the unlawful transaction. Re-diplock is another one of those cases that everyone has to learn at university about the hospital who receives money wrongly under payments from a will and pays off its very advantageous mortgage. And so when restitution claim is made against it, the defence was accepted on the basis that it would be wrong to require the hospital to repay. It had changed its position by paying off the mortgage. In some of the later cases, and it's Lord Justice Millett in Boscawen, he said the proper way to have acted in that case would have been to have said that the hospital was given a reasonable opportunity to find a mortgage on equally advantageous terms, because the result of the case in Diplock was that the people who'd lost their money under the will wrongly were wholly disadvantaged by the decision of the court. Turning to the factors in Bucknall then, and some of the factors that were raised there, if it was purely credit cards, which is one of the decisions that was raised, or the factors that was raised by Mrs. Wilson to justify non-repayment, in most of the cases that are an issue, merely saying I've paid off my credit cards is unlikely to be a sufficiently unusual step to take that you'd find change of position would apply. The loss of earnings opportunity, which is one of the factors that's raised by Mrs. Wilson in Bucknall, she says that she essentially decided to not take work on the basis that this money had finally come in from her relative. Well, that's a factor that's more likely to play in a change of position defence. The other factors which are raised on the slides as been raised in cases in the past are deciding to study at uni when you might not otherwise have done, deciding to take up a job, or deciding to refuse a job with a higher salary. All of those factors could be change of position with financial consequences, which could engage the defence. One of the factors which is slightly harder to give a clear response on is what happens if a recipient decides to change their spending habits. And the case that I put on the slides on that is the case of Philip Collins and Davis, in which two musicians who were described as being relaxed and philosophical with money decided to become even more relaxed and philosophical when they received money to which they were not entitled. They didn't expressly change anything that they were doing, but they allowed their spending habits to drift upwards, and that was found to be a basis on which they had changed their position, and therefore the money was not going to be repayable by them to the original person who paid it in wrongly. So there needs to be some decision taken as to future financial conduct, which would be inequitable to reverse. It's far easier to say that if it's repaying an extraordinary loan. It's far harder if it's a normal transaction, but there needs to be a slight grey area in between if you change your spending habits, not expressly, but in a slightly more extravagant way than you would otherwise have done. Some of the non-financial circumstances were outlined in Commerzbank and Price Jones. They were described as non-financial, but as I say on the slide, most of them have financial consequences which follow from them. It's hard to think of very many decisions which don't have some financial consequences flowing from them, which would be sufficient to found a change of position defence. So the three that are on the slide there, deciding to have more children, that's likely to cost a family more in expenditure, and so there are financial consequences which flow from that purportedly non-financial decision. Secondly, deciding to start and end a marriage. And thirdly, whether or not a personal injury has been suffered. The example that's given in Doyle and Jones is somebody who, because of the money that is given to them wrongly, decides to take a job which then causes them to have a breakdown in mental health difficulties, and therefore says that there has been a change of position on their part. Now, the response in Doyle and Jones is you still take a financial approach to how you quantify that personal injury and damages when working out what, if any, restitution should be made as a consequence of that personal injury that has been suffered because of the wrongful receipt of the monies. So although those are purportedly all non-financial changes which need to be taken into account, the financial consequences of those can be valued by the court and will need to be taken into account by the court in deciding what remedy to give and whether or not to be slightly more flexible in deciding to award something back to the wrongful payer, and not saying that the recipient is entitled to not pay anything back at all, and a complete defence. The next point is bad faith and what role that it plays. And there are two factors which have always been said to not allow the defence to operate. I'm going to run through these slides slightly faster so that we can get to the last stage. First of all, there is bad faith. Bad faith is sufficient to say the defence will not operate, and that's generally, as the test on the slide says there, paying away the money when the claimant is aware of it in restitution. And there have been discussions recently about the spectrum on which, in the case there is Sitco Bank and Trust against Barclays, how much knowledge is required in order to amount to bad faith, whether it is the reasonable person not investigating or whether it is actual subjective knowledge. The decision in that case says that it was not, for the purposes of a summary judgment application, unarguable to put the spectrum of knowledge in front of the court and say it could be as low as the objective person not investigating properly and turning a blind eye, but it could go all the way through to having subjective actual knowledge of the circumstances giving rise to the claimant's claim when the change of position happens. The second factor that's traditionally been stated as a reason for not allowing the defence to operate on change of position is wrongdoing. That, in some of the cases that it's been raised in, has normally followed the approach of Tinsley and Milligan, which is saying that if you rely on wrongdoing, i.e. illegality, you're not entitled to engage the defence in your favour. Whether or not that will still apply in the aftermath of Patel and Mercer is unlikely, and so you're probably going to have to go through the factors in Patel and Mercer to work out whether or not this is a case where the illegality is so severe that the defence can't work. A few other brief points on change of position. The detriment does not necessarily need to come before the enrichment in order for the defence to operate. So there are cases in which the money is received after the person has decided to invest or purchase something, and that anticipatory reliance is the change of position which is enough to engage the defence. So from a timing perspective, you don't need to wait until you've received the money before you take the act and change of position which will engage the defence. Secondly, there are 2 points on causation. First of all, there's the normal but for. If you would have done the act which you're relying upon for change of position without the payment being made to you, then it's very hard to say that you've acted to your detriment in reliance upon whatever has been paid to you. And secondly, there has to be express reliance on the payment that's been made to you. And so it has to be referable to the payment that's been made in order to pay out the money and engage the defence. Finally, I would just raise there are a number of different headings where you can't rely on change of position as a defence. 2 of them are on the slide there, undue influence and legal incapacity. There are a number of other cases on that point, but it's probably best on that you go to Goff and Jones and list out the various areas rather than me going through them now, because I'm conscious of the time. And so on that point, we turn at 10 o'clock to our concluding thoughts. Hopefully the chat function is enabled, so if you do have any queries that arise from the talk generally, then do by all means fire them across to us through the chat function, and we'll try and respond to those while addressing where we think we are in the aftermath of Bucknall and where the law and change of position addresses our thoughts on that. There are a few points on the slide that we've made there, which I think are our sort of takeaway points, which are firstly, the restricted way in which Mr. Justice Trower gave his decision. This was a preference decision, and he was very clear that he was only given a judgment in relation to section 340, 339 and 342. Secondly,
Before we leave that point, John, I'm going to very rudely butt in and say, yes, we must bear in mind that 4N is still the main case on section 423 and the exercise of the statutory discretion. It's been criticised, but it's never actually been held to be parent curiam, but it is ripe for a square, fair review in an actual section 423 case. So we're waiting for that to happen.
Which I think builds on a third point, which is that this is not going to be the last case in the area. It's one of those cases where we now have conflicting, or at least fairly critical decisions going each way in the High Court. There's a Privy Council decision which isn't technically binding on anyone, and so I don't think we would be surprised if there is a case that's likely to go a bit higher on this in the next couple of years to give a definitive view on where change of position sits in insolvency claims.
Yeah, that's right. And the approach of Mr. Justice Trower and Bucknall, it's restrictive of the reasoning in 4N, because essentially Mr. Justice Trower says change of position is relevant in that sort of case because it's easier to balance the transferee's interest with a single victim, as was the case in 4N, than it is to try and balance against all of the creditors. So that's sort of restricting it. We don't know what sort of position might be taken in a 43 case brought by a trustee when there are a bunch of other creditors in the background. And Mr. Justice Trower also thought the reasoning in 4N was more easily transposed to TUV or preference cases in single creditor bankruptcies and single creditor winding ups. For the same reason, because it's easier and practically easier to balance single interests than it is to balance one person's interest against a class.
Yes, and I think the other factor to just raise on the slide is, as I've already said, if you manage to keep the benefit of an actual asset after you've been paid it in an insolvency context, that's probably going to make your change of position defence considerably harder to run. So from a trustee's perspective, if the recipient still has a physical asset like a house or like a piece of property, it's going to make it far easier to run your claim against them and for the change of position not to operate. There's always been a slightly easier position when it comes to transactions at an undervalue or preferences in relation to limitation considerations, and now it probably means that when you're running that in change of position defences as well, you're in a slightly better position.
Yeah, absolutely.
So I've just noticed we've had something come through on the chat from Oliver Nelson, who's asked, has change of position been used to resist a liquidator's action under section 127? So I think the answer to that is the case of Conway, which is the Privy Council case, is a decision which is largely based on the equivalent provision of section 127, but in Cayman Island law, and that's the case in which the Privy Council were fairly tough on whether or not you'd be able to exercise a change of position sort of defence. Holly, do you have any thoughts on that?
Yeah, so you might recall at the outset of the talk, which seems a long time ago now, that I mentioned the case of Rose and AIB. It's a bit older, it's from 2003. And in that case, it was accepted by Mr. Nicholas Warren that it might be possible to raise change of position as a defence in a section 127 claim. I am not aware of a case where it has actually been applied. Not to say that one. All of the cases on section 127, and there are lots and lots of them, are outside talk, I think. But certainly it becomes more complicated because normally the discussion isn't really about whether or not there's a defensive change of position, but whether or not the payment ought to be validated. So all of the discussion in the cases gets subsumed into the discretion to validate or not, as opposed to the separate defences, restitutionary defences.
The other point on the slide is to just emphasise that whilst we've gone through how change of position works in restitution claims, it's not entirely clear from Mr. Justice Trower's judgment how general change of position defences in restitution are going to interact with the court having to take it into account in their discretion for the purposes of deciding whether or not to make an order to reverse a preference.
I suppose the most interesting point for me is that because the Court of Appeal, the appeal court, it was in fact Mr. Justice Trower, in Bucknall, came to the view that change of position wasn't established on the facts, he never actually commented on whether or not ICC Judge Jones was right to say that change of position would have been a sufficient factor when added to factors 1 and 2, good faith and the arm's length transaction point, to enable no order to be made. So although the judge said, well, absent consideration of change of position, factors 1 and 4 were sufficient, he never went on to give any indication as to what he thought of factor 3. So we still don't know whether, had change of position been made out, that would have been sufficient in combination with the other circumstances, but absent factor 4, to have resulted in no order, which is certainly what ICC Jones thought would be the case. He thought factors 1 and 2 plus 3 or 4 would be enough. And we don't know what Mr. Justice Trower thought about that, which is interesting. So in another case where change of position is made out on the facts, would that be enough? The other, I suppose, interesting thing to think about is what other exceptional circumstances might there be? So yes, it is exceptional to have a bankruptcy or a winding up where there's only a single creditor and therefore competing interests can be more easily balanced. But what else might be considered to be an exceptional circumstance? Well, the only clue that we're given by Mr. Justice Trower is that he thinks that Claridge is probably one of those cases. So he says there will be the very occasional case where it proves to be possible to give weight to a change of position by the preferee, while at the same time honouring the pari passu policy. But this is only the very occasional case, and Claridge is probably one. Now, I think the reason why Claridge is one is probably not so much because of the change of position element, but because of the inability to give restitution. In that case, you'll recall that the wife had taken out a joint mortgage with the husband. She'd used it to improve her home. The improvement hadn't necessarily added any value to the home, so she didn't have a benefit still in her hands. And it would be impossible, even if it were possible to sort of put a charge on the home for the benefit of any improvements, it would be impossible to put her back in the position she would have been in before the mortgage advance was taken out, because of course she remained liable on the covenant to repay the mortgage. So maybe those sorts of cases are better looked at as cases where it's impossible to have restitutio ad integram rather than cases where there's a change of position.
And in something like the Claridge case, you'd be hard pressed to see the change of position would operate as a defence in and of itself, because the real property cases that I went through earlier generally say that if you invested money into renovating a property and it's made no material difference, then you're going to be hard pressed to say that your loss isn't irretrievable, and therefore change of position won't operate. And so not only was the money invested in the property in Claridge lost, therefore you're in an irretrievable loss position generally, but you're also in the fairly difficult view from a discretion perspective, if you're looking at it from a pure insolvency context, of saying that a judge is going to make an order to restore something in the knowledge that whatever there was to restore, as long as it's disappeared, whether or not you need to frame that in change of position language, I'm not really sure is necessary. I think to some extent adding the words change of position to that sort of reasoning probably confuses and rather than assists anyone in getting to what the basis of the decision is.
Interesting. Do we have any more questions? I think John and I could probably talk about this all day, but we shouldn't.
Yes. I'm also not sure, I know Oliver has put a question in, hopefully we've answered it, but I'm not sure how well we've enabled the chat function, so maybe there are people typing away not to get through.
Well, Oliver, on your question, it might be instructive for you to have a quick look at the Bucknall decision, because Mr. Justice Trower does go through cases on section 127, doesn't point to any cases where change of position has actually been applied, but that goes on to make the same point that I did, which is that it's difficult to look at change of position individually in section 127 cases because of the fact that most of the cases deal with whether or not there should be a validation order, which is a separate discretion with additional factors to be considered. So there are, I think, 10 or a dozen paragraphs on section 127 cases and change of position in that judgment, which would be useful to have a look at. So if there's nothing further, John and I will bid you adieu and we will exit Chased by a Bear.
And I think for those who are interested in watching back and seeing the slides again, both the slides and the recording will be uploaded at some point onto the Guildhall website. But otherwise, join Holly in saying thank you for starting your Wednesday morning with us, and we will go, as Holly's put it, pursued by a bear.